Here we go. Good evening, this is Goldie. It's Wednesday, August 4th, 2010. I'm again transmitting from a secure location with a live studio audience. Please become a follower of mine on Ustream. Please note that this is the last show from this secure location, and next week may be a bit later, but I will email that on Monday. By the way, I hope to have someone monitoring, surveilling the chat on Ustream for any good questions. So go ahead and do that. I want to say, I'm doing this rant selfishly, for me. It helps me keep the burden of listening to me off of my friends, family, and dogs. A few days ago, I was speaking with some friends, and as I explained what I was doing in these rants, I realized that while I want to be dictatorial in this show, I'm trying to be coherent and stay on topic. So the questions of last week from the live studio audience were awesome, and I apologize for any questions that I did not answer. But keep those questions flowing, please. Let me summarize what I'm going to be talking about today. I'll be talking about the Fifth Amendment, takings, and the Supreme Court case of Kelo versus New London. I will always be agreeing with the Republicans' argument that regulations are profit and job killers, with the example of East 11th Street and East 12th Street in Austin, having onerous and duplicative regulations as to land use, and an eminent domain right, which is keeping lenders away. I'm going to continue ranting about surveillance cameras and false reasoning. I'm going to talk a little bit about MoveOn.org and their messages. I'll talk a little bit about immigration and the state of Virginia. I will also ask for any questions from the audience. My main topic of today is the Fifth Amendment to the U.S. Constitution. The portion that says, "Nor shall private property be taken for public use without just compensation." Intuitively, individuals understand that a public use has been defined over the years as land for roads, schools, and easements for railroads. Not wholly unjustified if you think about it. If a railroad could not take the land, each landowner in the path could charge whatever they want, making the building of a railroad prohibitively expensive. So usually, a commission of some kind is appointed by the governmental entity to determine just compensation, and while many landowners disagree and appeal the decisions of the commissions as to just compensation, the system works pretty well as to the public use. As this line of constitutional reasoning has evolved, however, we see that the idea of public use has been expanded to urban renewal, where a blighted area can be designated as needing a global change, such as East 11th and East 12th Street in Austin, which then got an urban renewal plan. In the event that you do not improve your property to the urban renewal plan's micromanaged land use, your land can be taken by the government and given to someone who will improve your property to what the government decides is the proper micromanaged use under the urban renewal plan. Would you buy a property that has the potential to be unilaterally taken in the event that you do not comply? I ask you, the studio audience, would you? No! Thank God. The answer is obviously no, as the uncertainty of what just compensation would be may be, and usually is, way less than what you put into the property. Republicans are correct that unreliable and uncertain regulations, in other cases, ignoring this terrible court case, cause a loss of jobs and profits as existing landowners and future potential developers and their lenders hold off developing an area where the takings power exists. Fairly simple concept. Along comes the Roberts Supreme Court in 2005. Remember Justice Roberts was appointed by George W. Bush, a so-called conservative. Fox News and Glenn Beck are very fond of talking about what the founders' original intent was. Well, let me tell you, the founders did not like soldiers being quartered in houses taken by the British without compensation. The founders did not like their land being taken away without a hearing. The founders were landowners, and the thought of the sovereign taking their land for anything other than a public use was abhorrent to them. Hence the Fifth Amendment. Now let me give you a hypothetical. You've saved all of your life to buy a lake house. You save for your down payment, find a location, get financing, and buy your dream lake house. You substantially improve that lake house. You add a dock, another bedroom, another bathroom. You redo the interior and exterior. You redo the landscaping, and you build a special ping pong room. Along comes a big hotel chain, let's say the Four Seasons, and they go to your local government. Give me the power of eminent domain so that we can take your lake house and the lake houses of all of your neighbors. They rightly argue that the increased taxes from the 30-story Four Seasons will dramatically increase the revenues for the city. The city grants them that right and starts making offers that the landowners argue are inadequate. Members of the appraisal commission agree with the Four Seasons offers and force you to take the offer. You appeal to the district court and you lose. They take your lake house and give you some dollar number. Now move and find another lake house. It's really unbelievable to even think of that hypothetical. The amount they may give you you may not be able to buy another lake house. And are you going to buy another one anyway? Are you going to risk that the W is going to take your next lake house and you'll lose hundreds of thousands of dollars, perhaps your retirement? I ask you, the studio audience, would you?
No.
No. The answer is a resounding no. Well, this is how the Supreme Court decided Kelo. In Kelo, properties were taken in an eminent domain action by the City of New London to transfer them to another private entity to further economic development. The Supreme Court held that the taking of land for economic development and the promise of 3,169 new jobs and $1.2 million a year in additional tax revenues was a permissible public use under the Takings Clause of the Fifth Amendment. Here it is again. Nor shall private property be taken for public use without just compensation. The court also held that the government's delegation of its eminent domain power to a private entity was constitutional. If you've heard any of my prior rants, you know the structural regulatory failures inherent in our system of governmental awards of our commons, especially in regard to privatizations. And in this case, the commons is also defined as the right to use eminent domain for redevelopment purposes, transferring land from one landowner to another landowner that lobbies those government officials. It's the same thing. It's the BP problem. It's the economic collapse. It's economic regulation. It's the exemptions for the auto industry. This stinks so much, my blood boils. It literally makes me sick to my stomach. Where is Glenn Beck's anger? Where is Sean Hannity's anger? Where is Rush Limbaugh's anger? Just because a Republican appointee to the Supreme Court says this is okay, it's okay. Are you kidding me? Look again at the disincentives. You've done substantial improvements to your property which may or may not be compensated. You lose money when the Four Seasons comes in. Are you going to do it again? No way, you are not. Similarly, on East 11th Street and East 12th Street in Austin, which I spoke about last week, the regulations there show a specific case of regulations costing profits and jobs, as Republicans always correctly claim. There exists a valid eminent domain power over a certain strip of properties in this blighted area. There are supposedly rules that govern the use of this eminent domain power in the urban renewal plan for East 11th and East 12th Street. However, there's at least one incident of a landowner approaching the city to buy his property on 11th Street, and that request triggered an eminent domain action. I promise you, he was awarded an insignificant sum as the just compensation. I would have been willing to buy every single property in that area for the price he was given by the city. The big problem was that there are no current appraisals justifying a higher price when he appealed, which is a catch-22 because so few transactions happen on those streets due to that eminent domain power that's in the urban renewal plan. I know it's complicated, but the bottom line is that less transactions, less lending, and less improvements happen due to the uncertainty of the use of an eminent domain power. Following Kelo, many states, I believe over 30, enacted some type of legislation in their own states, ripping away the power of eminent domain for purely economic reasons, allowed by this idiotic Supreme Court decision. Thank God Texas is one of them. Another reason to like Texas.
God bless Texas.
God bless Texas. This is a Supreme Court granting of a regulatory power to governments purely for the benefit of wealthy corporate individuals and donors. This is another reason why in most structural defect rant items that I've discussed, a constitutional amendment is the only way to guarantee that it is not overturned by a Congress or Supreme Court. Does anybody have any questions on the instability created when eminent domain is a possibility?
No, you explained it so well.
Thank you, thank you. All right, let's move on. I was talking with a friend from the studio audience last week who was saying that she would like to see more of my rants. And I suggested the surveillance rant. We then discussed that a little bit. She realized, shockingly, that I was opposed to surveillance cameras. I then went through the analysis done in the surveillance rant and discovered that she has a daughter. She said she was willing to have cameras pointed at her and her daughter in their bathroom, as it could not happen. I tried to impart upon her that her opinion to allow cameras to be pointed at her then translated into a camera pointed at me. I gave her an example of the data being released from 2 FBI workers in West Virginia. See Austin American Statesman article dated April 21st, 2009. These 2 FBI employees were arrested for looking at surveillance camera images from a private surveillance camera at a mall of girls changing into prom dresses. Remember my rant? I only used this as one example, and she again stated that she trusted the government agencies to keep the data private. I asked her if she trusted naked images to be kept off of YouTube, and she said yes. Really? I asked her if she thought the government was competent in a general way. She did not answer the question. I know that it's stupid to do this, but I'm going to go ahead and say she is wrong. The data cannot be protected, and there's irreparable harm to be prevented. Remember my argument about irreparable harm? Once the images of your daughter naked showering are out there, they're out there forever. She will not get hired by the law firm. I want to reiterate that you have a small R right. Hang on. It's water. I want to reiterate that you have a small R right to approve an entity to surveil yourself. Small R right. But when you do that, you've granted an entity a capital R right to surveil me. And you do not have that right. So keep your mouth shut. I've come to the conclusion that whenever you talk about a specific surveillance or privacy loss item, you must speak of it on the continuum of what is always a slippery slope. Body scanners at airports, total recall sobriety checkpoints, surveillance cameras. A friend recently asked me about the full body scanners at the airports. Before I started ranting, I realized that any time you start talking about one of the subjects that relate to privacy, you must talk about the whole continuum of privacy and the incredibly slippery slope that the continuum points towards. Complete and total non-privacy everywhere for everyone. Think of the movies Minority Report, 1984, and Total Recall. So when you talk about the scanners at the airport, you're not ever just talking about the scanners. You're always talking about the erosion that the scanners cause to our fundamental right to privacy. When you talk about surveillance cameras, you're always talking about the erosion that the cameras cause to our fundamental right to privacy. When you discuss the Obama administration's request for a relaxation of email and browsing privacy laws, you are always talking about the erosion that such eavesdropping causes to our fundamental right to privacy. Put all of these things together, and that is defined as the slippery slope. Another way to look at this issue, which I've been doing, is to ask someone in another country what their feelings would be about the police being able to turn a surveillance camera in their daughter's direction. A friend in Samara, Costa Rica related a story to me about her husband and a female cousin who were walking along the street in Samara. Apparently, 4 cops stopped them and claimed that there had just been a robbery by a couple that matched their description, and they would need the female cousin to come down to the station to be questioned. Risking a beating, my friend's husband said no, and I demand to see the captain. They probably said that he was being a revolutionary and he would have to come downtown to the police station. This is serious. Upon arrival in the eventual meeting with the captain, he was released, and the captain apologized, but warned him that he should tell nobody. Asking my friend if she would trust the police to have surveillance cameras looking in her windows, she just laughed skeptically and said, absolutely not, and never. So if you think about it, the motives that led to the release and misuse of surveillance data and images in the 2 countries are the same motives. Young men manning the cameras and looking for lights in the bathroom windows so they can see a young girl naked. In the US, it's just a bit more sophisticated and an easier download to YouTube, causing permanent, irreparable harm. A July 28, 2010 New York Times editorial entitled "Breaking a Promise on Surveillance" shows that the Obama administration, far from being a polar opposite of the Bush administration, is a mirror image of the Bush administration, or as I say, more of the same. It's so disgusting. I need to read the editorial to you. It's just a technical matter, the Obama administration says. We just need to make a slight change in the law to make clear that we have the right to see the names of anyone's email correspondence and their web browsing history without the messy complication of asking a judge for permission. It's far more than a technical change. The administration's request, reported Thursday in the Washington Post, is an unnecessary and disappointing step backward toward more intrusive surveillance from a president who promised something very different during the 2008 campaign. In a 1993 update to the Electronic Communications Privacy Act, Congress said that Internet service providers have to turn over to the FBI on request electronic communication transactional records. The government says this includes the email records of their subscribers, specifically the addresses to which email messages were sent and the times and dates. The content of the messages can remain private, which I believe. It may also include web browsing records. To get this information, the FBI simply has to ask for it in the form of a national security letter, which is an administrative request that does not require a judge's signature. But there was an inconsistency in the writing of the 1993 law. One section said that Internet providers had to turn over this information, but the next section, which specified what the FBI could request, left out electronic communication records. In 2008, the Justice Department's Office of Legal Counsel issued an opinion saying that this discrepancy meant the FBI could no longer ask for the information. Many Internet providers stopped turning it over. Now the Obama administration has asked Congress to make clear that the FBI can ask for it. These national security letters are the same vehicles that the Bush administration used after the September 11, 2001 attacks to demand that libraries turn over the names of books that people had checked out. The FBI used these letters hundreds of thousands of times to demand records of phone calls and other communications, and the Pentagon used them to get records from banks and consumer credit agencies. Internal investigations of both agencies found widespread misuse of the power and little oversight into how it was wielded. President Obama campaigned for office on an explicit promise to rein in these abuses. There is no reason we cannot fight terrorism while maintaining our civil liberties, his campaign wrote in a 2008 position paper. As president, Barack Obama would revisit the Patriot Act to ensure that there is real and robust oversight of tools like national security letters, sneak and peek searches, and the use of material witness provision. Where is the robust oversight that voters were promised? Earlier this year, the administration successfully pushed for crucial provisions of the Patriot Act to be renewed for another year, without changing a word. Voters had every right to expect the president would roll back authority that had been clearly abused, like national security letters. But instead of implementing reasonable civil liberties protections like taking requests for email surveillance before a judge, the administration is proposing changes to the law that would allow huge numbers of new electronic communications to be examined with no judicial oversight. That's the end of the editorial. I almost have no comment on this, as I believe that the editorial in the liberal Democratic Party New York Times says it all. Think back to 2008. Obama ran on a platform that he would be a different privacy, environmental, peace-loving, Afghanistan, Iraq, and drug war eliminating, anti-corporate, non-George Bush. It turns out he is just more of the same. The only difference is that unions and state governments get the stimulus funds, and in Bush's time, the Halliburtons and the rich got the stimulus in the form of no-bid contracts and huge tax cuts, respectively. As to the pointless and extremely costly drug war, just watch the California marijuana initiative on the ballot this November. How do you feel to have upwards of $50 million of your taxpayer funds going to fight against it with a DEA advertising blitz, as was done to each medical marijuana initiative, as well as decrim initiatives in Nevada and Colorado? I ask you, do you feel it's a waste of your taxpayer money to help Pfizer keep marijuana off the table of consenting adults and have OxyContin and Paxil there instead? I ask you.
No.
Do you feel it's a waste? I'm in. Which has more side effects? I mean, how many people have ever had to go to weed rehab?
Nobody here.
Nobody's gone yet. Now, does anybody have any questions about Obama more of the same, surveillance? Anyone?
How do they get away with it all the time, man? Every 4 years. Every 4 years. How do they do it?
Well, this gets us back to, that's a good question. The question is, how do they do it every 4 years? And the answer is the structural regulatory defect if we're talking solely about the drug war, we know that under Citizens United, the ability of Pfizer and the other drug companies to put as much money into campaigns completely overshadows our ability to lobby or put $20 into somebody's pocket and have them listen. We need a constitutional amendment, which the BP, all the BP rants, it's the same exact problem as the BP regulatory rant. It's the same structural regulatory defect that needs to be fixed. Thank you. Okay. Continuing on, I talked about the mosque at Ground Zero from last week. There was a July 31st, 2010 New York Times article entitled "Debate Heating Up on Plans for Mosque at Ground Zero," and it's full of election messages. First of all, the mosque is not going at Ground Zero. It's 2 blocks north of Ground Zero. However, it highlights the old election message differences between Republicans and Democrats, where Republicans have always complained of Democrats not caring about national security. Various groups and individuals have called for this particular religion to not be allowed to put a church where it's properly zoned and permitted to do so. Newt Gingrich at least has called for Ground Zero to be declared a national battlefield that would allow regulation to prevent certain uses. At least he has a reasonable argument. From the article, I'll read, Oz Sultan, the program director for the center, said the complex was based on Jewish community centers and YMCAs in Manhattan. It's to have a board composed of Muslim, Christian, and Jewish leaders, and is intended to create a national model of moderate Islam. Being a member of the YMCA, I know of the violent and radical views that are propagated there. But that completely irrelevant statement aside, this shows the clear ignorance of the American people to the slippery slope concept. Once you prevent one church from being built somewhere, all churches could be prevented from building somewhere. The Jewish Anti-Defamation League has recently denounced the project. That's one group that I will never join. And they want me to not comment on the Israeli-Palestinian issue. This is certainly a good position for an oppressed people to take, self-proclaimed. Yesterday, one of the last hurdles to the project at the Historic Commission in New York City passed the project 9-0. I received an ACLJ, that's the Christian right-wing lobbying group, email, saying that the fight's not over and they're continuing to file suit. I ask, why is it that the very religion that may someday be in the minority in the U.S. is the one leading the charge to erode the fundamental protections of freedom of religion found in the First Amendment? Why? I don't know, actually. My opinion, I've got an opinion, is that it's pure racism and religious intolerance. And as a friend said, they're loud and have a lot of money to spend. Does anybody have any questions about U.S. racism or intolerance towards Muslims in the U.S.?
Not for this show.
Thank you, thank you. We'll do it during the week, which I really do appreciate getting these emails and comments during the week. Remember last week I told you all to go to moveon.org and sign the petition for the constitutional amendment to say that corporations are not people? And do you remember that I said as to other issues that MoveOn does, I have no opinion? Well, I just received an email from them dated July 30th regarding the Helen Thomas seat in the White House briefing room. By the way, Helen Thomas got booted by her news organization for saying some very public, very anti-Israeli, but not anti-Semitic comments. Quoting from the email, Dear MoveOn member, as early as Sunday, the White House Correspondents Association will decide which news organization will be awarded a recently vacated front row center seat in the White House briefing room. The contenders? National Public Radio, Bloomberg News, and Fox. Yes, Fox, which we all know is actually a tool in the right-wing propaganda machine, not a legitimate news organization. They simply don't deserve the best seat in the White House briefing room, a seat held for years by journalist Helen Thomas until she retired recently. As much as I watch Fox and comment on messages, they are no less of a news organization than MSNBC or, seriously, NPR. This email that they sent me is full of pro-Democratic Party message, which I warned you about. Do not sign this petition. People say that NPR is unbiased. Well, that's actually impossible. Every word that's ever written or spoken anywhere contains the prejudices and slants of the drafter. My words and rants certainly do. Just because Fox is better at getting people to believe and parrot their message does not make the other networks better or good, and it does not make Fox worse or evil. MoveOn is a pro-Democratic Party message purveyor, and sometimes their interests are aligned with mine, but not this time. As to some of the messages in the media that you're seeing right now, The Virginia Attorney General just wrote a legal opinion that Virginia state troopers can ask someone detained, "Where are your papers?" as in Arizona. You'll be hearing words like groundswell of the public, vast majority of Americans, overwhelming public opinion, supporting Arizona, and "Where are your papers" laws. Don't believe any of it. Americans are too ignorant and ill-informed as to the law to even be able to opine as to whether it should exist at all, or whether an anti-racial profiling provision will stop racial profiling. They don't even know what racial profiling is. I think we all feel that the law, about the law, that it will not stop cops from specifically looking for brown people. Just ask any cop off the record. This is a continuing message, election message that you're going to be seeing, and watch the Democrats tread very, very lightly. I'm going to give you some stray thoughts. This one is a failure of a fringe acquaintance. I don't call him a friend, but he's a fringe acquaintance. He posted a doctored picture on Facebook. He claims he's in advertising. I somehow feel like it's a failure. There's something bad about it. I don't know what it is, but there's something bad. The person who was in the picture looked like she was surfing really well. Maybe she's not here. And she is getting better. And I would hope that she would get good enough to actually have that kind of picture taken. But not that much better. And she did not admit in her comment that it was doctored. It just smells bad to me. There's just something that doesn't feel right about that. I don't mind people doing it, but there's just, I don't know, something. Here's another one. I met a gentleman, in loose terms, from Texas yesterday, who had to delete his Facebook page in order to get a job. Too many drunken, roach-holding, vomiting incidents to be able to get a job at a legitimate company was his problem. By the way, he thinks that by deleting it from Facebook, it cannot be found by a prospective employer. What a doofus. Remember the rule from the surveillance rant. Once an image is out there on the internet, it's out there forever. This is the classic example of someone younger not understanding the significance of the constant loss of our expectation of privacy and the need to keep some portions of our lives out of the public domain. Good luck, dude.
God bless.
And God bless. And just when you thought it was safe to go back in the water, today the New York Times reported that a federal judge overturned California's same-sex marriage ban, and that the issue will probably be decided by the Supreme Court, the Roberts Supreme Court, that decided Kelo and Citizens United. Anybody remember 2004? John Kerry lost to Bush due to same-sex marriage bans in several key states. A Karl Rove genius initiative. To reiterate, my view on gay marriage is that it should be legal for purely economic reasons of estate planning and administration following the death of a partner and medical decision rights. It's just cheaper to society. One last thought of the day. People ask, how do girls in Costa Rica deal with their cheating boyfriends? And I said, and I said,
What cheating boyfriend?
and I said, they're just like Republicans. They lie to themselves.
There you go. Nice. Nice.
That's all there is today. We talked about eminent domain, surveillance, MoveOn.org's messages, the mosque at Ground Zero, immigration enforcement, and messaging in Virginia. Are there any other questions that anybody might like to ask?
Chris, did you raise something?
Yeah, the problem is the political system. Everybody's going to change everything, but it never happens. So,
Well, that's why we know that when you throw in a bunch of Tea Party supporting legislators this time, they're going to get there, as they usually do, whether they campaign on a constitutional amendment for term limits or fixing these structural changes or not, and then once they get there, they like the power. So we know we have to change whatever is allowing that to happen. Both parties, or Tea Party, or Greens, or Libertarians. We have to change the actual system, and that requires a constitutional amendment.
Is that possible? Both sides have mastered the art of bullshit.
Both sides have, and if we...
we're still believing it.
Okay, the question is, both sides have mastered the art of bullshit. And the Tea Party would have been the way this year, if BP had continued spewing, to maybe change some of the structural regulatory problems that we have, which are unlimited spending by corporations on political campaigns, revolving door for regulators that go immediately, wink, wink, nod, nod, out to the same people that they regulate, and term limits for the senators and congressmen, because they're always trying to get reelected as soon as they're in there.
Well, is it
So-
time to rewrite the Constitution?
It's time for constitutional amendments. And so MoveOn.org has a correct petition out there for the constitutional amendment. At least it's a start to change the definition of a corporation from a person, which allows them to give $20 million to every senator's campaign for advertising. That's the defect. We can fix that one if you can get enough people, and MoveOn's doing it. I feel good. This is what I was talking about. MoveOn's doing the same
They
thing.
tell us when we elect them. And then when they get into office, it never happens.
It's not them. I know. It has to be almost revolutionary.
Right.
And
So rewrite.
That's what I'm thinking.
that's what we're saying. We're doing an amendment to the Constitution that has to be done. So the idea of these Tea Party candidates thinking they're going to go in there and affect change is absolutely and totally ridiculous. Can't be done.
You gotta change the collective consciousness of the whole nation.
You have to intelligize. We need a larger group of intelligent people that think about these issues.
Canadians?
And I don't even know how that can happen. And I don't know how that can happen, but I appreciate your question. That's a great question. Okay, I want to thank all of our sponsors. Like I said, all of them disagree with me in one or more of my stands. Piano by Angelo.com, Angelo Limbesis, who teaches and plays keyboards all over Austin. For cocktail parties, holiday parties, anything. ZetaDesign.com for all of your decorative painting needs. She can make anything look like anything. AustinAreaPlumbing.com for all of your plumbing problems and redos. TicoAdventureLodge.com, T-I-C-O AdventureLodge.com, a small hotel in Samara, Costa Rica. CNC Surf School in Samara. La Vela Latina in Samara, a great sunset restaurant in Samara. What was your name? SamaraBuilders.com. We'll work out the compensation later. They are in Costa Rica and they build green, which I'm sure they have defined on their own. We've talked about Costa Rican regulations, so God bless y'all. And Amhar Tequila at www.santospirits.com, an extremely smooth tequila. I want to thank our live studio audience for their patience and inputs. You may tip your glasses back. Cheers. Thanks. God bless.
It's water.
It's water.